Thank you very much, Stephen, for the introduction, and good evening, everybody. As we said, I'm going to talk about whether you're prepared for mergers and acquisitions. The areas that I'd like to cover this evening are why are we particularly talking about this now? I think Stephen's already given more than a few hints as to why this is such a topic at the moment. Why might this affect your firm? What actually drives us to mergers or acquisitions? And how do we actually make it happen? So where do we start? So how do we approach another party to merge? Is it actually going to fit together? So carrying out some due diligence to find out what you're really getting. How much does it cost? So what's the value or what's the structure you're going to put in place? Of course, anything that's got a price has to be paid for, so we need to get some funding. And any deal that's done properly will, as you all know, have plenty of paperwork and legal documentation just to support it all the way through. Now obviously with any transaction, the day that you shake hands and sign on the dotted line isn't the end of it. So I'm just going to spend a couple of minutes at the end talking about the post-merger impact. So why are we talking about this now in particular? As Stephen's mentioned, certain provisions of the Legal Services Act came into play on the 6th of October this year. Mergers and acquisitions have always happened in the legal market. I would imagine that quite a few of you have experienced them at some point in your career. But the provisions of the Legal Services Act have turned the historical rules whereby law firms could only be owned by lawyers, or more recently by a majority of lawyers, I think it's 75%, completely on their head, whereby anyone, slightly flippantly, can own a law firm now. So we're going to be going from a traditional partnership or LLP model to what we're calling alternative business structures. So these alternative business structures, one of the key points is the ownership is not only lawyers, and that external funding is a possibility. Now, a lot of the press are dubbing this the Tesco law, because they're convinced that Tesco will just say, yeah, we're going to have a bunch of lawyers somewhere in our shop. Now, I do believe that Tesco have said that they're not interested, but the co-op has shown that they are interested. So they've got the funding in place to get themselves a new area of income, which is great synergies with what they're doing already. They've got the financial services business, they've got a bank, and then adding on the legal practice to it will maybe take people all the way through to their funeral care. We're also looking at mixed service practices, so at some point in the future you may actually find you lawyers sitting next to us accountants in the same office, which could be quite entertaining. But what's common to all of these bodies is that they all need to be licensed by a regulatory body. And as Stephen said, the Solicitors Regulatory Authority isn't yet authorised, but we hope this will happen in early 2012, and that's when things might really start to move. As I talk to you this evening, I'm going to use the generic term law firms. Now, these rules do cover solicitors, but they also cover barristers and licensed conveyancers. But just to keep things simple, I'm going to talk about law firms. Now, any of you who think, yes, it's all in the press, but I don't think it's actually going to make a difference. I've got an example here for you in Quality Solicitors. Now, they are just one of several brands that are being discussed in the legal press that are looking to change things. I think the phrase is being disruptive. Just got a few other names on the screen there, but I'm not going to talk about all of them this evening. The Quality Solicitors brand, for those of you who aren't familiar with it, is applying a national brand to local practices. Now, a few years ago I met with a leading designer. We were talking about brand and so on and so forth, and he said, well, what is brand? And he defined it perfectly for me. He said, it's a series of promises that doesn't change over the time. So just like McDonald's or Coca-Cola or Heinz baked beans, you know exactly what you're getting. And that's exactly what Quality Solicitors are picking up on. They're saying, our promises are just the start. They have recently signed a private equity deal with Palamon, which will enable them to fulfil their ambition to expand to 30 to 40% of the national market. Now that's absolutely huge, and I haven't seen their business plan, so I'm not sure how they're going to get there or whether they will get there. But the funding is giving them weight behind those ambitions. What's happening here is that the investment is going into Quality Solicitors to enable them to provide the marketing, branding and back office support to the underlying firms, all of which are quite small firms and really can benefit from this. The incoming chairman said at the time of the investment that this is a once-in-a-generation opportunity to create a strong national network. And I think that applies to the whole of this new legislation. there are huge opportunities to do things that you might not have been able to do before. So why might this affect your firm? As I say, I don't know if change has really started. I think Stephen would agree with me. Things haven't really moved yet. But probably over the next 2, 3, 4, 5 years, we will start to see change. And it will affect all sizes of firm. I think a lot of people are saying it's only going to affect the small firms. But I think some of the larger firms are seeing their way into the smaller business end. I think what's going to really push this forward is succession planning. Now, in last week's accountancy age, the average partner age in smaller firms is 59. Are they ready for this move? I know we're talking about accountants here, but I can't imagine the statistics for solicitors are that different. I think your firm can consider whether there's new opportunities for growth. Some of those things that you've been looking to do for a long time, but haven't actually been able to because of lack of availability of funds and so on. For the rest of my presentation, I'm going to provide some thoughts on how your firm can be prepared. When I'm talking about either side of a transaction, I'm referring to mergers, but primarily just for ease of a technical term. But I'm talking about acquisitions, I'm talking about being the acquirer or the acquired, and I'm also talking about those of you who might be interested in working with a consolidator or becoming part of Co-op or Tesco's Law. So, what does drive a merger? Obviously you don't just wake up one day and scratch and think, I'm going to do a merger today, that'd be really good use of my time. Mergers are only ever done as a route to fulfil your strategy. Now obviously you have to have a strategy to be able to fulfil it. And as our legal services team are always reminding you, you need to have a business plan. Just because we're professional services practices doesn't mean that we're not businesses, and businesses all need a business plan. You'll set out why the business is there, so which areas you're covering, where it wants to go. So you're looking to grow, or is a lifestyle business just perfect for you? How are you going to get there? So are you going to develop people in-house, or is the time for a merger? Got all the right partners in place, and if you have, are there some succession issues on the horizon? Practice culture. Now this is absolutely key. You know as well as I do, we don't use that much equipment in our day-to-day work, but what we do use is people. We have internal clients and external clients. And making sure that we'll all be able to work together in the same culture is absolutely key to a successful merger. Obviously the business plan will look at the expected financial results and returns. And it will come up with some contingency plans, some what-ifs. And I think one of the key ones for this at this stage is a reaction to an approach. Are we looking to be acquired, or are we going to bat them away? Really think about that first. And as we've already mentioned this evening, at a very minimum, you need to have a SWOT analysis of your firm to understand its strengths and weaknesses, and the opportunities and maybe threats that the new legislation provides. So, how do you actually go about finding the merger partner? Well, who you merge with is defined by why you are merging. And I'm going to use the example of the Menzies merger with Morley & Scott just a couple of years ago. Morley & Scott was a top 50 accountancy practice. I was one of the Morley & Scott guys, had an office in London, we had an office here in Solent, with which you're probably familiar, and we had an office in the Thames Valley. Menzies, a Surrey and Hampshire firm, were growing, they were covering the same type of clients in the same areas as us, but they didn't have a London office. Huge synergies were seen in bringing the client pool together in Surrey and Hampshire, but also in moving into London, and together we're working to grow the London office. Another way of fulfilling the overall Menzies strategy has been the recent merger with what's now become Menzies Business Recovery. Not only expanding in size, but expanding into an area that we didn't cover at the time. Now, when you find your merger partner, they may already be on the market, they may be waving their hands and saying, I need to retire, or whatever it might be, or they might be more quietly open to an approach. But the key to any merger, however you find it and whoever it's with, is making sure that those synergies are in place. Now the approach can be very formal or quite informal. For example, if you've got two high street lawyers, one in commercial and one in taxation, they might think we could generate real benefits to everybody by merging together. Maybe just a partner's lunch and a handshake would get the process underway. But at the other end of the scale, we've got quite formal approaches, so maybe we're looking at consolidators or we're looking at Co-op or Tesco Law. They might be using agents to find particular targets, or the targets may have an agent saying, come and buy me. But however the parties come together, and however you find that merger partner, you need to have a task force, or even one partner responsible for the merger. Mergers and acquisitions take up a huge amount of time, and at the end of the day, you can't give up your day job. You're here to practice law, you're not here to run a merger. And especially where valuations are based on turnover or earnings. If you're losing turnover and earnings, you're losing your value. And there's just one point I make from the point of view from being a member of staff as opposed to a partner. One of the things that I appreciated through the Menzies and Morley and Scott merger was that we knew what was going on. Instead of just seeing the boardroom door close and the partners scurrying in and out of each other's office and thinking, well, who's going next, we actually knew what was happening. We could see it was something positive for our firm. And I think that was really, really important, certainly to me. So how do you actually make it happen? It sounds like a great idea. Well, very important for me, and I would say this because this is my particular area of expertise, is due diligence. So finding out about each other. Now, when you go clothes shopping, you can try on a suit. If it looks shopping, you can just put it back on the peg. If you're merging with another firm, it's not till you've merged that you actually realise whether it's the right thing for you. We need to look at the valuation or the structure for the deal, how we're going to get the money to do it, and as I said before, the all-important legal documents. Generally, at a very early stage, if you're not willing to share that much information, maybe a non-disclosure agreement hasn't been signed. But it's very useful for some of the senior guys to get together and compare their business plans and see whether the merger works for both. See if they've got a shared ethos and exchange some early information. Now, what I put on the slide is just sort of some examples of the information that you might want to share. So, what are the total fees? Adding those together, does it get you to where you want to be? What are the staff costs? What are the staff costs as a percentage of fees? Is the firm as efficient as you are? Obviously, we'll need to know the number of staff and the number of equity partners, and I'm sure the equity partners would like to know what the average profit is. But obviously, the key is the synergies of all that coming together. So having exchanged information and taking everything at face value, you really want to know what you're getting. Now, those of you who, like myself, had the joys of working in the pre-Windows era may remember Lotus for their spreadsheets. Maybe not, being lawyers, you might not have done as many as I did. There's a fantastic function on it called WYSIWYG. What you saw on the screen was nothing like you were going to get on the printer. So you went into this fantastic function, WYSIWYG, and it promised you faithfully that what would come out the printer was what you saw on the screen. It didn't. It was always completely different. And that's what we're doing with due diligence. We're seeing whether what we think we're getting is actually what we are going to get at the end of the day. Now, I've covered 6 areas of due diligence here. Some you might do in more or less detail, obviously depending on how well you know each other. Commercial due diligence, well, that will look at the type of clients you've got, the fee structure that you've got, and the potential synergies. The financial due diligence will look at what we're doing, how it translates into results. Are there good earnings, are there bad earnings, is there a lot of bad debts, does the WIP convert into fees quite quickly, and so on. Taxation, now this would look at the taxation aspects of the legal practice. It wouldn't look at the tax of the individual partners, but I would advise every partner involved to take their own taxation advice, obviously, unless you're a tax lawyer yourself. Legal due diligence, checking whether contracts are in place, whether there's any disputes, any reports to the legal ombudsman, any PI issues. Management and culture. Now I'm going to come back to this later because, as I've said before, it's absolutely fundamental. And obviously IT. Are the systems going to talk to each other? And this is an area that we have seen quite commonly. People start to work on quite early in the process to make sure that on day one post-merger we can all do our jobs. So, being prepared for due diligence. Now, it might be both ways. If it's a pure merger, firm A will find out as much about firm B as firm B wants to find out about firm A. But if you are looking at being part of a consolidator, they won't tell you as much about them as they expect you to tell about yourselves. There will be huge information requests. Each of the 6 areas of due diligence will want to know a lot of information. I think fantastic. I filled in the due diligence questionnaire, and then they'll come back and they'll ask you loads of questions. So there will be a huge amount of time spent on it. Questions, interviews, more questions. And in order for the process to be run efficiently, the information needs to be ready and it needs to be reliable. Now, a lot of this is going to be down to, for example, the accounts team, making sure that management accounts and everything are up to date. We sort of joke that this might arrive out of the blue, but if you are looking for a merger or an acquisition, just start thinking about doing some due diligence on yourselves. Are your management accounts up to date? Has everyone got an employment contract? And so on and so forth. Just a bit of housekeeping. So for the last few weeks, you've had all these people crawling all over you, asking you endless questions. And at the end of it, it's like, well, what's this all about? Well, first and foremost, you get a beautiful report out of it, and if you're really lucky, there might be some graphs in it. But what the report will really focus on is, what have we found? So what? So what does it mean? And now what? What are we going to do about it? So let me give you an example of that. Looking at the due diligence, there's lots and lots of old debts on the ledger. So what? Well, is the turnover not generating cash quickly enough? Or have we got some dissatisfied clients? Or are there some not real invoices on the ledger? We'd investigate that to find out what the facts were, and then we'd decide what was going to happen next. We might want to chip away at the valuation. We may want to get them to put better systems in place. Or if there is evidence of poor work, so for example lots of bad debts and then lots of credit notes, you probably don't want to go ahead. Now, as I've mentioned a couple of times, cultural fit is absolutely paramount. I've spoken to a couple of people after the earlier rounds of this presentation, and they have said that this is the point that for them has been the most important when they've merged. Very nice couple I met, they've merged 2 or 3 times in the last 5 years, and they've had one failure in their merger. And it was nothing to do with the quality of work, it was nothing to do with the management information, it was purely because the people had a completely different culture. Neither was wrong, neither was right, they just didn't match. So in order for a professional service firm to move together, but everyone has to be motivated, everyone has to understand why we're here and how we're doing it. And culture can be hard to change, and it can be very hard to understand. You can't just walk into a room and sniff it. You really need to know how people react and how people are expected to react. So one area that might be proposed is a culture review. Now this is a sort of workshop style environment where you take a team from one firm, a team from the other, and work through some scenarios together and see whether they actually looked at them in the same way or whether their views were diametrically opposed. So having got to the stage that you think, yep, these are the right price for me, obviously everyone's going to know what the price is. Now, one of the areas of my work, I do valuations, and I can guarantee you, if I do a valuation for the buyer, it's not going to be the same as the seller's valuation and vice versa. Whatever fancy models we've got, the answer won't be the same. So the actual value is only ever going to be what the 2 parties agree to. And it's generally somewhere in the middle, a little bit of shuffling, and quite a lot of putting it into the deal structure so things work properly. Now what we saw, I think it was about 10 years ago, when the accountancy world went through a similar change in legislation and we had consolidated firms. Some of those consolidated firms were listed on the stock exchange, so details of the multiples that were being paid for the firms became public. So those firms that were merging privately, shall we say, got a distortion as to the value. They said, I want it to be X times earnings, even though as a small firm it might have been X minus quite a bit times earnings. And that actually distorted the market. So even where there's a metric in place, it doesn't always apply to you. Obviously the deal structure is fundamental, as is the new ownership structure going forwards, whether it be as a new partnership or part of a PLC or larger group. Where there's a price, there's funds needed. What are the funds needed for? Well, to meet your existing financial commitments, maybe some payments to exiting partners who've chosen that this is the time to retire and hand over to their successors. You might need some upgrades, or just simple things like some moving costs or refurbishment costs. And the sources of funds, well traditionally funds have come from internal funds, that is retained profits, or maybe from partners' further capital investment. But what's happening with the new structure is that external investment will be available, and this will supplement the partners' investment and maybe enable them to do the things they've wanted to do before. So this investment may come from a private equity house, as we've seen with Quality Solicitors, from an investment group, or from a listed parent. And as I say, legal documentation is absolutely paramount. Now, I spoke to a solicitor last week who said, well, we've done mergers and we haven't had any legal documentation in place. What do you think? And I must admit, I had to excuse myself and go and get quite a large glass of wine at that point. I think it's important that legal documentation is in place to make sure the transaction happens properly and that everything is in place. So we've had the completion meeting, we've signed on the dotted line, all the legal documentation is beautifully in place. So what happens next? Well, it's very key that the firms are integrated. It's all very well saying, well, we all answer the phone in a different way in the morning. But what we have to remember is pretty much on day one, everyone's a new boy and a new girl. We've got new colleagues, we've probably got new systems, we might even be in a different office. We have to make sure that we integrate. Within a couple of days of merging with Menzies, those of us in Morley & Scott in London office, we were treated to a presentation by the incoming Menzies partner, and he explained to us why the acquisition had taken place and the importance of the office to Menzies' business plan, so we understood why we were there and how we could help out. We also had some more informal areas of integration. I remember within a week or so, I sat down with Ross Wiggins, who also carries out the same areas of work as I do. I got out a report that I had done, he got out a report that he had done. We ran through them, chose the best bits, merged them, shook hands and off we went. It wasn't quite as simple as that, but we did need to make that effort to talk to each other, to understand how things work. But integration isn't just about smiley faces, it's actually about measurement. Is this doing what we want it to do? So have we got management accounts that show that we're making the returns that we're expecting to do? Now, often the legal documentation will set out metrics for them, and there'll be dates at which comparison needs to be taken. So, in summary, it will take time to complete the deal. I think if you think it's going to take 3 months, it's bound to take at least 6. On a day-to-day basis, it will take time and energy to action the deal, as well as continuing your day job. And that's why we propose that burden on, maybe some of the other partners help out with their portfolio. It will take time to come together as a firm. I do joke that Ross and I sat down and half an hour later we were sorted out. But it probably did take sort of 9 months or so for the two corporate finance teams to really understand how each other works. And I'm happy to say it's a much stronger and larger team now. And of course it will take time to get your return on your investment. So I think my final words are, mergers and acquisitions may be on the horizon, and synergies can be possible from them. There will be time costs involved, and there will be real costs involved. You do need to look before you leap, but if you do look ahead, and you make sure that you are prepared, then you should be able to reap the rewards you're looking for. Thank you for listening.